you should know these. At the end of the Constitutional Convention, when its passage was certainly still in question, Franklin rose to give a final speech, and the gist of the speech is that he was in favor of it despite its faults, and he closes by saying, and the opinions I have of its errors I sacrifice to the public good. I have never whispered a syllable of them abroad. Within these walls they were born, and here they shall die. And if somebody was looking for the political advice that pushed over the ratification of the Constitution, in purely political advice position, that was the political advice. That anyone who ascribed their name to that document should not, after leaving that building, acknowledge any doubt, any reservation, or any debate. That's why Madison's reports of the Constitutional Convention were not made available. Now, everybody knew that there were going to be Federalist and Anti-Federalist writing in the papers, but it would have significantly undermined the ratification process in each of the colonies if the statements of a Northern delegate regarding the prerogatives or preferences of a Southern delegate had been disclosed abroad. And so it was a profound genius on the part of the founding fathers to deliberate in private and to declare in public. And that is advice that has been sadly lacking, at least in this country, with regard to the negotiation of treaty, the taking of political positions. You know, we have a tendency now to deliberate in public and then to either not decide or decide in private. And that is precisely the opposite of the valuable lesson the founders taught us, and it's one that we really do need to remember. The second one in here, when I was a clerk to Judge Keller of the Superior Court in Pennsylvania, a notable legal figure in the community was defamed. And because of the position of the individual, he was not in a position to fight back, and the defendant in the case was a major media outlet, so it wouldn't have been a fair fight to begin with. But as I was going through my antiquarian materials, I chanced upon an epistle from Father Franklin, and I very humbly sent a note over to the individual, and it was the equivalent of the note that they sent Dick Nixon, where they said, "Don't let the bastards get you down." And that was the equivalent of the note that I sent, but I sent with it Benjamin Franklin's essay, which is formally entitled "An Account of the Supreme Court of Judicature in Pennsylvania viz. The Court of the Press" in 1789. This is more popularly known as the Freedom of the Cudgel essay, the gist of which is that a man's reputation is valuable, and that if the Court of Pennsylvania is not willing to follow the Constitution that was prepared, I don't know whether you know this, but the Pennsylvania Constitution is far more detailed, far more broad than the First Amendment on the freedom of the press and the freedom of speech. And that was partly due to the influence of James Wilson and Benjamin Franklin. And the bottom line here is that the freedom of the cudgel, if you've ever had someone who was defamed, I think that you need to give it to him as an antitoxin. The gist of his theory, though, is that if you're not going to protect people, then the law should provide for an alternate remedy, and the alternate remedy was that the person defamed should have the right to beat the defaming party with a stick no wider than their thumb until they could be driven out of town. Somehow I think that's not one of the prunings or improvements that we're likely to make to our law at this time. However, I do think there are times when we get caught up in the 24-hour news cycle, everybody, all politicians lie, and everybody says other people do awful things and it doesn't mean anything. I think that's all wrong. I think that's all wrong. I think the value of a person's reputation is as important as any property right they will ever have. And that we need to get back to a vigorous debate on where that line should be drawn and what is or is not acceptable in the process of the campaign. What is or is not acceptable in the course of political discourse. Poison in the water does not improve the ecosystem. You have to draw a line somewhere, but some of what, and when you think of Franklin, you do not think of a man who did not respect the press. Not at Pennypacker's Colonial cases, say that 3 times. Pennypacker, brilliant guy, and he collected up in the Colonial records, and there are books, the volumes of the Colonial records. The problem is, the Colonial records are cluttered up with every conceivable item of business that a government could do, and it's in a each transaction basis, and you go back and forth between things, and you got to have the patience of Job or a supercomputer to make any sort of sense of it. So Pennypacker, at a point in history, decided that he would undertake the incredibly arduous task in 1892, 200 years later, of trying to reconstruct a decent cross-section of colonial cases and justice in America. And I picked out a couple of them to give brief description. If anybody's interested afterwards, I actually have the Xerox copies of the original documents, but I found typing it up was easier to get through more of them. The first one was Proprietor versus Manston in 1683, and that's a little late. We think the Salem witch trials, we think a little earlier than that, but they weren't done calling people witches until well into the 1700s. But they actually had a trial. She was required to post bail of 50 pounds. She had a trial 2 weeks later, and she was found not guilty. And I could go through, there were great evidence, and I had a long list of the evidence there, but I thought the interesting thing about the case, if you read the accounts of the witnesses against her, and then you read her response, she knew more about the law of hearsay than half of my opposing counsel last year. I mean, and she backhands it. And when the guy says, my mother told me blah, 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 she says, I care little for the account of so-and-so. If his mother had shown up, I would have answered her. I mean, I'll probably steal that for my next hearsay objection. But they had the trial, and William Penn personally presided. He gave the charge. Pennypacker says nothing's preserved. One of my historical research assignments right now is to actually find out the truth or falsity of that, because I frankly don't believe it's true. I think that he gave a bad charge and Pennypacker gave him the charity of the grave, because I don't think he wanted to admit that William Penn had given a charge that was essentially to convict. What I love about the jury's finding is, you're in a proprietor's colony, okay? You've been selected as a jury person in a witch trial that the proprietor himself is presiding over, and you don't want to convict. So their verdict was, brought her in guilty as having the common fame of a witch, but not guilty in the manner and form as she stands indicted. No sentence imposed. I mean, that was worthy of Bill Clinton. I guess their verdict was, it depends on the meaning of the word is. The next case I thought was kind of cool. Many of you know that I'm very active in ADR, Alternative Dispute Resolution, and we tend to think of that as a fairly new concept. I mean, it was a hot topic in the early 90s, and now it's ubiquitous. But it turns out in 1684 they'd already invented it. In the case of Johnson versus Peterson, they apparently had some significant disputes, and 1684, and the governor and the council together, okay? So picture this. You got two guys who are important enough that their disputes are being personally heard by William Penn and his privy board, okay? And the outcome of the case is that they should shake hands and forgive each other, post a £50 apiece bond, and the records of the court concerning the matter, they weren't expunged. I mean, there have been records that I thought really should be expunged. It was not fair to my client, it was not fair to the community. You know, this stuff should be gone. But the most I can do is get an order that says expunged, which sounds like SpongeBob SquarePants comes and, you know, wipes out the ink or something. They didn't expunge the record here. They ordered the records burned. There's a finality to, you know, and if the guy wants to appeal the expungement, not exactly going to help. Didn't work for, they acquitted Joan of Arc on her second trial. I'm sure she was very gratified. Actually, it's a segue into what I'm going to do later. I have snuck in a few family members into the presentation, and I just want you to know that I have no idea whether the guy was actually related to me, but there were 4 people who testified at the retrial of Joan of Arc, and one of them was Claude Barbin. And his claim to fame, sorry about that, folks, his claim to fame was he was one of 4 people who could actually testify that they had met and discussed matters with Jeanne d'Arc in Orleans at the time in question. And in more French history, you know, the king was not of age when they executed her. So when he became of age, there was a legal right to have it reviewed. He reviewed it, and that's how they reversed it. But you should also remember that the Duke of Burgundy and the other people who, you know, wanted her burned were no longer in power, so that kind of helped too. The contempt of court, I thought, was pretty funny. In 1685, the court apparently wasn't getting the respect it deserved. Get this sort of guy with a powdered wig doing a Rodney Dangerfield, I'm not getting no respect. And what actually happened was they created a rule, and they decided that anyone who interrupted the court without permission would be fined by the bench, and as they determined. To my knowledge, this is the first published rule of court in Pennsylvania, and it didn't take them long to enforce it. Thomas Howell was fined for breach of the rule and 1 shilling. My written comment is my written comment, but my oral comment is I'd have paid good money. I honestly would have paid good money. There are 2 events in court I would pay good money to be able to go back in time to see. I would like to be able to see Thomas Howell. I don't know what he said. You know, that's bovine scatology or something when the court did something, and they fined him 1 shilling, and his reply was, "Let the court get it how they can." It's like, you know, and you think, wow, that's a rude litigant, and he's in contempt of court. But isn't that exactly what Andrew Jackson said to John Marshall on the Trail of Tears? You've made your decision, now let us see you enforce it. I mean, there are interesting overlaps and connections in history, and it seems to me that this guy was ahead of his time. I do not know the year that the Scarlet Letter was written, but I'm pretty sure it was after 1693, okay? And I'm gonna go out on a limb on this, and I'm gonna say that, you know how Al Gore was the inspiration for Love Story? Okay, or at least, you know, that's one version of events. Anyway, in this particular case, John Clues and Eleanor Arm were found, who were at that time married, okay? They were married. And they were fined for committing fornication, okay? I can't make this stuff up. And if you go through any of the colonial case records, And fornication is one of the favorite charges. And, you know, half the time it's the father bringing against the boyfriend, and the daughter's the one saying that, you know, he didn't do it, or I love him, Dad won't let me marry him. But not this one. This one, they're married. I don't know what they did. You know, they don't ask, don't tell policy. They don't give us the details, but they were fined 50 shillings each. And given the fines that they gave for other things, you know, 50 shillings was a pretty big fine. That's not the disgusting part. This case actually truly disgusts me. And that's why it's in the materials. That's why it's in the materials. This is the inspiration for the Scarlet Letter, because these judges declared that Eleanor should stand at the whipping post for a quarter of an hour with a paper upon her breast bearing the inscription, I here stand for example to all others for committing the most wicked, notorious sin of fornication. What?
Yeah.
I mean, where's John? You know, what happened to John Clue? I don't have a clue, and neither did Pennypacker, or he wasn't telling. But that I thought was a case worth doing. I have to do the Rambo case very quickly because I do want to get to the John Wilson materials. Okay, gonna give you a short version. Long facts, well worth the read later. Don't try and read them now. They are killer facts. This is another case of fornication, okay? But this guy who's a captain, okay, we don't learn that until Rambo 2. You know how they don't tell you everything in the first show? Some things you only get in the sequel. Okay, we're gonna get that in the sequel, but Captain John Rambo, his brother is going to marry one of the cock girls. So he decides that he wants the other one. So he climbs up on the roof, lifts the shingle, jumps down under the bed. Now, there are 3 girls on this bed, okay? 2 of them testify in court that he said he was gonna stay. They said, you know, don't stay. And he said he was gonna stay. And then we got off the bed and slept on the floor till morning while he spent the evening with my brother on the bed in the room where we're sleeping on the floor, okay? And the father drags the guy in, and I love the one daughter's testimony. Again, I can't read it all, but the one testifies that the devil take me if I don't marry you, that was the promise of marriage, was the devil take me. And I thought, wow, who knew Meatloaf was a legal history fan? Because if that isn't a ripoff, if his Paradise by the Dashboard Life, I'll love you till the end of time, and now I'm praying for the end of time. I mean, that's clearly taken straight out of this Colonial Pennypacker cases. Anyway, so the first case, they find that he made a promise to marry, he has to get married, and he has to marry her before she gives birth, and she has to deliver the baby to him afterwards, because remember, we were a very civilized country, and the father owned all children. And so in Rambo 2, which I subtitled, you know how all sequels have a subtitle, Hell Hath No Fury. Rambo 2, Hell Hath No Fury. In the second one, she gave birth. By then, he was getting ready to marry somebody else. And he demurred to the pleading successfully, but he inadvertently opened the door to further pleading by denying the contract for marriage. And so on evidence, that the evidence showed that he refused to support the child, but then the judges inquired, and what it actually said was the child would die before she gave it to John. So he wasn't the deadbeat dad. She just wouldn't do the condition precedent, if you will. But I will say in a stunning development, cliffhanger development at the end of the second episode, which is pretty much required for any really good show, the court actually ordered payment of 150 pounds, which at that time was a heck of a lot of money. I'm sad to say that I left off a copy next to that in Colonial's Pennypacker cases was another case where a former slave, black girl, had begotten a child by a particular person, and attempted to have that person found to be responsible for the child. The court listened to the testimony of the white business owner, and the court ruled in favor of the white business owner. And if you were disgusted by the Scarlet Letter case, this one will disgust you even more, because not only did they not find that he was responsible for the child, when there's no evidence in the record that he wasn't responsible for the child, but they ordered her whipped publicly for having made the accusation. Pennsylvania justice was not always a paragon. Another case, just briefly bring to your attention, those of you who do study legal history know that the principles of free press were established in the Peter Zinger case in New York, and that Andrew Hamilton was the attorney. Of course, those of you who know that, you're wrong. In fact, the Proprietor versus George Keith, William Bradford, and Thomas Budd with Peter Boss was in fact the first time in English jurisprudence that a court of competent jurisdiction left to the jury the determination of the seditious character of an alleged libelous paper. And it was the attorney in that case, and his name is Samuel Jennings, and not Andrew Hamilton, who deserved the credit. And even more damning, this just in, it turns out that Andrew Hamilton had visited Philadelphia at a time when this particular case was still being written about in the tabloids. And so, of course, he stands accused not only of being a fraud, but a plagiarist. To which I have but one reply. And those who have gone to prior CLEs will know that my best advice to a young lawyer, and the first advice I give to my associate, is simply, was given to me by a Harvard professor, a fairly humorously inclined one. It was simple. Plagiarize. Let nothing evade your eyes. Only please to call it research. The fact of the matter is there probably was a connection between the defense in the Bradford case and Andrew Hamilton's defense in the Zinger case. And one of the differences in the cases that's important is that although the publication of Keith, Bradford, and their conduct was almost certainly seditious, the jury was selected by, I'm a little trouble here. The jury was selected by the proprietor, and the verdict was rendered by the proprietor. And after the people had been tried for sedition, they retained their jobs. I'm thinking it wasn't as hard a case as Jennings thought it was. Just saying. Bucks County case contribution. I'll go through these very quickly because I'm almost out of time and it practically kills me. I will tell you the good news about the James Wilson materials is they're self-contained. What I did was I went through his Constitutional Convention quotes, his speech regarding the ratification, and then his law lectures. I have the 2-volume set of the collected writings of James Wilson. If anybody comes across something that they want additional materials on, they're welcome to them. Go ahead.
I just tell you, being on the committee, we're always looking for other programs.
Right.
We could reprise the second
Right.
part, maybe
Right.
in the next 12 months sometime.
And I'm more than happy to do that. I just wanted to note, unlike most manuals, there are really good quotes there, one of which I am going to use in court on Monday morning in my opening argument regarding evidence. And he just had a felicity of expression that is worth noting. Now, I am going to get to the, I shot your horse twice, and then I became a judge. A guy named Joseph Woods, he's out in Bucks County. He's got a neighbor, he warns his neighbor, keep your darn animals off of my corn. And week one, he fills his shotgun with rock salt and shoots a horse in the flank. And he figures that's a pretty good warning. Well, the next week, the horse comes back, and he drops it, one shot, right between the eyes. Boom. They go to court. They bring in witnesses. And, and the prosecution thinks it's got to, prove its case, which is kind of funny. when you get to the defense witnesses, because prosecution brings in people, I recognize the tire track as being the track of the horse, and I know this horse, and it was this one, and forensics evidence on who killed the horse. And then they get to the wife and daughter of the guy who shot the horse, and the wife says, yeah, the horse was there the other day, he told him not to be there. He shot him with rock salt, and the horse came back and he shot him again, and the daughter gets up and says, shot the horse. Jury convenes and decides to award 5 pounds damages. The defendant says, ain't paying it. The court says, remand him to the sheriff. Now, I looked. I saw no record of detention. I saw no record of payment of fees. And the one thing in Bucks County is, when you paid a fine, you entered a fee, you paid a tax, they tax dogs. I mean, if you want to know something, if you had family that was in Bucks County before the revolution, I mean, you can know exactly how many animals they had, what kind of business they had, how many acres they owned, whether they had a dog. I mean, it really, and the fines, there's a good chance your relative was fined 3 or 4 times for different things. You'll find out a lot about your family by the fine records. Anyway, I certainly did. Anyway, the interesting part about that particular story is they came back in and sued him again, and he still hadn't paid the fine, so they upped it a little. And again, I saw no satisfaction of the fine, but I did see something that really amused me, and that was at the next court, one of the original witnesses was in on a different case, and it listed the judges, and it was the guy who said he wasn't paying the fine that was now the judge of the county. So so that's why I shot your horse twice and became a judge, was in the in that particular one. In the materials, there is also another witch case. I will tell you that apparently intelligent people figured out that the better way to handle the whole witch trial thing was not to wait until the nag next door got around to bending the ear of the sheriff, that you should go to the county court first and sue them for defamation. And so this is a case of defamation, and it's under the title, "You Called My Wife What?" And I can just tell you that the gist of that particular case was they found that it was in fact defamatory, and that being ugly did not mean you were a witch. Again, I can't make these facts up. Now, the next document in your material, color, and we are at our time, but I do want to tell you about this piece of paper, if you'll indulge me. This is actually an indictment from 1742. And what's really cool is it's the indictment against a lady named Elizabeth Pitcock. And there's a Pitcock Creek and a Pitcock Road in Bucks County today. Well, Elizabeth Pitcock apparently beat the crap out of my 6th great grandmother. That's what the gist of the indictment is that she set upon my great grandmother and beat her to the point where they were in despair of her life. And it's testated by Francis, the attorney at law, Elizabeth Barbin, Roberta Cooper, and it's signed over to the government. And the next page, just in case you thought I was making up the Barbin part, I blew up so you could read that that was in fact her name. And then the Elizabeth Pitcock, and then the next detail is of Benjamin Pitcock. And I've always told my clients that karma is a bus that never runs on time, but it makes every stop. I was looking for something else the other day, and I came across a case that mentioned the name Pitcock. And it was an early case, and I thought, maybe there's a relation. As it turns out, Benjamin, the husband of the abuser, died, and for the next 40 years, his family fought each other in court. I would say the karma bus took care of it. I haven't been able to find out what happened on the indictment. The record of the case has been lost. But I'm satisfied that 20 years of estate litigation was enough to punish anyone still living in the crime. Yeah, you've been a very attentive audience. I am sorry that there was more material than there was time. but maybe I will come back and address the other issues. If anybody does have a question, I will say that I'm perfectly happy to stay, and if you have a particular area of historical interest, I might be able to get you something. Thank you very much.